Thank you so much for joining us. Making the legal case against the Trump administration's policies on budget cuts, diversity initiatives, immigration, access to private data, and more. Promoting a crackdown on smartphones in schools, dealing with constitutional issues, all part of the workload these days for our guest, Attorney General Andrea Campbell. General, welcome.
Thank you for having me. We're busy.
Yeah, you sure are busy. It's great to have you here.
Great to be on.
We don't have the time to go over every one of the lawsuits against the administration that you're involved in many cases, along with other AGs. But we've already seen the White House skirt judicial authority, whisking that tough student out of state before her lawyers could get into court to get an injunction, for instance. And there's a rising tide of rhetoric from the president and fellow Republicans questioning the authority of courts. What happens if they start openly defying court orders?
Well, I want to be careful not to suggest a sense of alarm for folks in that respect, because what we know to be true is that our lawsuits are working. We are in court to protect access to funding in the public health context, education context, you name it. We get billions of dollars from the federal administration, and we're going to keep fighting for Massachusetts. I'm going to keep pushing for this funding to come to our state. We need it. Why? Because affordability is the #1 issue. So our lawsuits are working. The courts are working. And what you're seeing is a blatant attack by the administration, including the president himself, to try to undermine the credibility of lawyers, undermine the rule of law, and undermine our judiciary with the hopes that fear-mongering is created so that we don't do our jobs. But right now, it is working. We're going to keep using our litigation tools along with any other tool that we have in the office to protect our people. Well,
what if the authority of the courts and the legal system conflicting with what the executive branch claims is its authority, if that winds up in the Supreme Court, where are we then?
Well, I will say...
Is that where it's headed?
Well, there's this question of, is there a constitutional crisis right now? The average person is like, what the heck does that mean? It's not an on and off switch. It is a turning of the dial. And what I am seeing in my team is that we are heading in a dangerous direction. You cannot function in a society and have accountability, checks and balances, which I think every resident in Massachusetts wants, if we do not have a democracy or society of laws. And what does that mean? We have a legal system that promises our people certain things. The First Amendment, they promise them rights. They promise to deliver life, prosperity, all of these things. And if you suddenly move from a democracy or a constitutional system to something else, where this president, for example, may want to be a king, all of those things that government has promised you, you will not receive. And the last I checked, if you want issues of affordability, cost of things to go down, products, services, that can't happen in a society that does not have a legal system that is working.
One last thing on this before we take our break. For many, many years, we've heard debate and discussion over the concept of judicial overreach, of courts that are in the minds of some getting involved in legislating, and that's usurping the prerogative of a co-equal branch of government. We've all heard these arguments. It seems to me right now you and other attorneys general are basically serving as an opposition party at a time when Democrats in Washington are out of power. Should we be concerned about that long term as a distortion of the balance of power?
Well, I know I didn't come into 2025 looking for a fight. I wanted a federal administration that we could work with to help us reduce utility costs, help us bring down the cost of housing, protect our elders, protect our consumers from theft and fraud. And we're not getting that. We're getting unlawful action over and over again, blatant disregard for the Constitution. And you can do all of this work of affordability, consumer protection, public safety, do it lawfully, as we do in the office every single day. And that's what we're going to focus on, while also holding this administration accountable.
General, there was a hearing at the State House last week on the constitutionality of Auditor DeZoglio's push to audit the legislature. We know voters overwhelmingly approved that last fall. You voted for it, right? Mm-hmm. Okay. So Lawrence Friedman, a constitutional law professor at New England Law, said, quote, "There lies the possibility that an unscrupulous auditor would use the opportunity to audit these functions as a wedge with which to subject the general court to continuous audit requests, and should they fail fail to respond to the auditor's satisfaction, litigation over those requests, he goes on to say, that ultimately could undermine the legislature's ability to do its work. Do you think Diana DeZoglio is an unscrupulous auditor? Do you agree or disagree with the professor's comments? And are you prepared to argue that in court?
I absolutely support the will of voters. I think government can always be more transparent, and I've been on the record, including with our public records law, which there are parts of government that are exempt from complying. Our office isn't. That being said, there are constitutional limitations on what the auditor can audit of another branch of government, namely the legislature. So we have been working with her. And although she's out there publicly suggesting that we are the barrier to this audit, that's just not true. When we go into court, as I do representing any state agency in Massachusetts, the court will ask you, even though we may look fabulous, what is your legal argument? Why are you here? What relief? What's the scope? We need to hear from the auditor. What's the scope of your audit? What are your legal claims? We have not gotten that information fully, so we can then not go into court. And the legislature has also been forthcoming. They want to be helpful. They want to resolve this, but they also have concerns about the constitutional limitation. So yes, we may be in the middle, but we need the auditor to produce some more information before we can go into court.
I got to push back a little on that because my information is they don't want to be helpful to her, they don't like her, they don't trust her, and they think she'll abuse this authority.
Well, I know as I'm having to navigate the auditor in the legislature, right now the legislature, from our vantage point, is not putting out misinformation. They have asked and complied. When we ask them for information, they send it to us. The auditor has suggested she has given us all the information we need to be able to move forward on behalf of the people. That is not true. And in order to move into court and to ask the court to then follow up on implementing this ballot question, it also has to be constitutional. And so we need that information to proceed. And sadly, what most folks don't know, when we approve a ballot question in this state, we approve it, but the sad part is it doesn't go through whether or not it is constitutional. So it's backwards, right? So we clearly have to change that. The founders and others who drafted our Constitution didn't do that. But most folks don't know that, so we will keep pushing on their behalf.
I want to use our final minute here to talk about a bill you filed several months ago, the Study Act, that would institute a bell-to-bell ban in public schools on smartphones. You can't bring a smartphone into school or it gets put in a secure bag. Now, ideas like this have been around for some time. Some districts in Massachusetts have acted. I believe that's correct. Why haven't they all? What's the holdup? This could be the single biggest issue plaguing families of school kids in Massachusetts right now.
Technology, cell phones, these platforms that can be very addictive to our young people, number one issue. I actually think it's the issue of our day for our kids. The anxiety, depression, mental health epidemic we're seeing in Massachusetts as a result of technology. And so you have an addictive device with these social media platforms on top. In schools, we're saying through this piece of legislation, ban these devices. Teachers should not have to be the enforcement police of cell phones. Young people also support this because of the uptick in bullying and harassment they're seeing on their devices while in school. They're there to learn, and we as adults have to protect them. So I am hopeful that the Study Act will hopefully be passed because it will not only ban cell phones, but most importantly, complement our existing litigation against Meta and Instagram and TikTok for the harms they're causing our young people through these devices, most importantly, these apps.
We're almost out of time, but what's the holdup?
There's no holdup. We're working it through the State House.
No, you are trying, but what there's resistance apparently to this.
I wouldn't say the resistance is something to be alarmed about. I think there's a lot of questions of what would this mean. We want to work with school districts, educators, the Teachers Association. They all support us in this. Young people too, parents. Now we're working it through the State House, but this is the number one issue. Young people are in schools to learn. We want a positive, non-disruptive environment. And at the same time, we want to hold social media companies accountable, which this legislation would also do to ensure these platforms are safe and also responsible to our parents and our young people.
Well, Godspeed on that one. The whole smartphone thing is a disaster. I would recommend to our viewers this, I think it's Netflix series Adolescence, which documents the toxicity of this. General, thanks for being here.
Oh, thank you for having me.
Come again soon.